Now, University of Ghana and the UPSA, get ready for the very first round of the contest. And this is the general round, where you have 5 questions and you are given 30 seconds to answer a question. There will be only 2 attempts at a major question. If you answer correctly, you will be awarded 3 points. But if you are unable to answer correctly, the question will be passed on to your opponent for a bonus mark of 1. And there will be only 1 attempt in the bonus session for only 15 seconds. So let's get ready right now. And beginning with the UPSA Faculty of Law. Let's talk some land law. What constitutes denial of title by two subjects?
What constitutes denial of title by a stool subject is when the owner of the usufructuary interest makes a grant to a person without the consent of the stool, and then or the stool lands, and also in instances where the usufructuary interest holder makes use of a particular land for mechanized farming or large farming activities without the consent of the stool.
What constitutes denial of title by stool subjects?
So what constitutes denial by stool subjects is when a person claims that the land does not belong to anyone but him, and he denies the allodial ownership of the stool, and then
that is sufficient, and that is correct for the full marks, and that was a good answer on your second attempt. Now to the University of Ghana School of Law. What do we mean when we say a bare license? Bare license.
So a bare license refers to a permission granted to a person to use land without paying any form of consideration and can be revoked at any time.
And that is comprehensive. Thank you very much. And the contest begins on a good note of showing their prowess in a special way. Now to you, the UPSA Faculty of Law. What do we mean when we say contractual license?
A contractual license is a license where the parties involved or one party involved has been given the right, or the person has an interest in the. It is when the party involved, one has been given the right, or the person is paid an amount of consideration for a particular work, or he has an interest in that particular work.
At the mention of the valuable consideration that passes in furtherance of such a contract, I will give you 2 marks for this attempt. A contractual license is a license granted in furtherance of a contract for valuable consideration, and that was essential in your answer, such as the right of lodgers in a guest house or a hotel. Now to you, the University of Ghana. Who, still talking some land law, who is the proper person to sue or to be sued in respect of stool lands?
According to Order 4, Rule 9, Sub Rule 1 of the CI 47. It is the occupant of the stool or the regent that is the proper person to sue in respect of stool lands.
Thank you very much. And that is the answer with so much specificity. The occupant of the stool or the regent where there is a vacancy, caretaker where there is a vacancy, or sometimes too as appointed by the Council of Stool Elders. Now to you, UPSA Faculty of Law. Please listen carefully. In the article that you are so familiar with, 14, Clause 2 of the 1992 Constitution, it provides that every person shall be entitled to his personal liberty and no person shall be deprived of his personal liberty. What are the two exceptional circumstances by which a person may be deprived of his personal liberty? Two exceptions. Give us only two.
So when the person has been, the law imposes a punishment upon a person who has committed a crime for a prison sentence, and then where a person is a drug addict or drug addict, also in terms of education.
That is when the person wants it's in attempts to fulfill a court order by detention or saturation, and also where the person has an infectious disease or any sickness.
Right. So in both attempts, you are correct, except that in the first attempt you were a bit stepping out of the way. So you are not to be deprived of your personal liberty, except under these circumstances where there is an execution of a sentence or order of a court in respect of a criminal offense of which the person has been convicted, as you said, an execution of an order of a court punishing one person for contempt of court or for the purposes of bringing that person before a court in execution of an order of that court, or in the case of a person suffering from an infectious or contagious disease, a person of unsound mind, a person addicted to drugs or alcohol, you mentioned it, you perfected it, or a vagrant for the purpose of his care or treatment or the protection of the community, the purpose of education or welfare of a person who has not attained the age of 18, or for the purpose of preventing the unlawful entry of a person into Ghana, or effecting the expulsion, extradition, or other unlawful removal of that person from Ghana, or for the purpose of restricting that person while he is being lawfully conveyed through Ghana in the course of his extradition or removal from the country to another. And finally, upon reasonable suspicion of a person having committed or being about to commit a criminal offense under the laws of Ghana, you will justifiably, constitutionally be deprived of your liberty. The University of Ghana School of Law, in Article 277, we have come across this article during this competition of the 1992 Constitution. Who is a chief?
So, according to Article 277 of the 1992 Constitution, a chief is a person who hails from the appropriate lineage or family and has been validly nominated and schemed or installed as a chief in accordance with the requisite customary law and usage.
That is comprehensive. A round of applause for her. And those are the defining words. The person must be hailing from the appropriate family or lineage. You don't get up, walk into some family and begin to say that you are entitled to be installed a chief or a king or a queen mother for that matter. And you must have been validly nominated, elected or selected or installed and skinned or installed, any of those words as she used, as a chief or queen mother. But it doesn't end there. That installation, installment, and skinment must be done in accordance with, as she said, the relevant customary law and usage of that community. Now to you, the UPSA Faculty of Law. We move away from chiefs and from land. The legal effect of mistake, we're talking contracts, at common law, is to render the contract void ab initio. That's the contract never existed at all. However, in equity, mistake operates in 3 ways. Name them.
The first is in an action for specific performance. The second is in an action to rescind the contract, rescission, and then rectification of a contract.
And that is correct. A round of applause for her. That is the answer with great precision. Now to you, University of Ghana. Let's still talk some more contracts. What constitutes an operative misrepresentation in the law of contracts?
Okay. What constitutes an operative misrepresentation is where the misrepresentation existed at the time of concluding the contract and induced the other party to enter into that contract.
Thank you very much. An operative misrepresentation consists of a false statement of facts made by one party to another before or at the time of making of the contract, which is intended and in fact induces the other party to enter into the contract. Now, by the lack of the specificity of the reference to false statements, I think that I should be kind to let you keep 2 of the 3 points. Now, UPSA Faculty of Law. Let's see how we have been reading our thoughts. Maybe streets on thoughts. State the rule in Raylands and Fletcher, 1860.
The rule in Raylands and Fletcher is that when a person, in his unnatural use of the land, brings onto the land or carries onto the land, accumulates onto the land anything or something that can, if it escapes, can cause peril to the land, and if the person does so, it is at his own peril. I mean.
Thank you very much. The essential elements have all been manifested in your rendition. The rule states that a person who, in the course of a non-natural use, you stated that non-natural use of his land, accumulates. And Lomoki reminded you of how important it was to refer to accumulate. or is held to be responsible for the accumulation on it of anything likely to do harm. And importantly, if it escapes, and you did not forget to use the word escape. Those are the most important. Thank you very much, and you are deserving of the full marks. Now let us proceed, and this will be the final question to the University of Ghana. Since we are talking thoughts and thinking of some nuisance, what is private nuisance?
The essential elements in a private nuisance is the disturbance, pestilence, or pestilence to a person, which is not general to the community, but to a particular individual.
So what is the effect of that disturbance?
The effect is that it puts the person who has been disturbed by the pestilence or the disease or the disturbance to sue whoever is causing that to recover for damages.
I'll give you the mark for it. Thank you very much. Private nuisance in thoughts. We are referring to unreasonable conduct. He spoke about that, including, as he said, pestilence, and it causes annoyance or inconvenience. He spoke about that to a person or causes injury to land or interferes with the enjoyment of the land. I think that I should be kind enough to let you have the marks for that attempt. On that occasion, please, a round of applause for our contestants. Ladies and gentlemen, at the end of the first round in this contest between the University of Ghana and UPSA, the two have made equal points, 14 marks each. A round of applause for them. The Lord challenge. We now move to round 2, which is the buzzer round. There will be 6 questions in this round. You only press your buzzer, and within 30 seconds, tell me if you know the answer to the question or the statement that I'm reading. I don't have to complete it. And if you do so, you will be awarded 3 marks. Now, for every incorrect answer, 1 mark will be deducted from you, and there will be only 1 attempt in this quest. How does the buzzer for University of Ghana sound like? Thank you. And UPSA? Now let's begin. Here is your first statement. It goes to all of you, any one of you, in fact. I'm a very good rule for lawyers and judges. Yes, UPSA.
The golden rule.
That's the golden rule. Both lawyers and judges use me when the language of a statute is ambiguous. I can be used to interpret the statutes in order to ascertain the intention of the legislature. The usual consequence of using me is that words which are in the statute are ignored, or words which are not there are read into it. And I am the golden rule. UPSA. Here is statement number 2. I purchased property in good faith and for valuable consideration.
Equities, darling.
Equities, darling, and that is correct. I heard your bell first before I heard that of the University of Ghana. I purchased property in good faith and for a valuable consideration without knowledge, actual or constructive, of the seller's title defects. In fact, you can describe me as bona fide purchaser who acquires property for value and without notice of the equitable rights. Yes, UPSA is right. I am equity's darling. Here is the third statement. Fastest fingers, it does appear that is where we are. I am one of the most important kinds of equitable reliefs available for mistake. Yes, University of Ghana?
Mistake.
Rescission.
And that is correct. Stop whispering to yourself and say it loud. I am one of the most important kind of equitable reliefs available for mistake. My essence is to set aside a transaction. I am rescission. Now here again, we meet a friend that we have met. That's the only clue I can give you. We have met very many friends. I am, once again, I am a rule. Am I a rule in land law or constitutional law or interpretation? No. I'm a rule in thought, and I would perfectly apply where a person who, in the course of a non-natural use, yes, UPSA.
Relance versus Fletcher.
The rule in Relance versus Fletcher. Their bail went first, and I'm sure I'm correct about that. A non-natural use of his land accumulates or is held to be responsible for the accumulation on it of anything likely to do harm if it escapes, is liable for the damage to the use of the land of another, which results from the escape of the thing from his land. I am that rule, devised in 1866. Ladies and gentlemen, now let's go to our statement number 5. I am a Latin maxim which states that act or omission to act is only a crime if before, yes, University of Ghana?
Nulla crimen sin previa lege.
And that is correct. Round of applause for him. I'm a Latin maxim which states that act or omission to act is only a crime if before the act or omission was committed, there was a law declaring the act or omission in question is a punishable offense. And Ghana's constitution in Article 19 is emphatic about this. Nullum crimen sine previa lege. Now to the very final statement. And ladies and gentlemen, it's a very brief statement, which means you have to be faster. I am a law that regulates persons and activities within a particular territorial jurisdiction. Who am I? Yes, University of Ghana?
Customary law.
Yes, UPSA?
Private law.
Right. So the answer we wanted was either national, domestic, or municipal law. So that is where we come to the end of this round, with none of you succeeding. The law challenge. And at the end of the second round of this contest, the University of Ghana makes 5 points as against UPSA's 8 points. A round of applause for our contestants. The law challenge. At this juncture, we move to the third round of the contest. There are 3 questions that each one of you will be asked And your job is to identify the personality the quotation I speak about is attributed to. You may also be required, in addition to that, to state the case in which the quotation can be found. You have 30 seconds to do that. A correct answer attracts 10 marks. There is 5 marks for a partial answer. And there will be only 2 attempts at each question. There is no negative scoring for incorrect answer. And each team will be given the opportunity to identify one personality within the legal fraternity. That will bring us to the 4th question, so to speak. And this is a non-transferable round. Gentlemen and ladies, here we go. And this time beginning with the UPSA Faculty of Law. Who made this statement and in which case? Here in Ghana, the Contracts Act has changed the law. With a fanfare of trumpets, and has made it clear that third parties, not parties to a contract, can sue, but if and only if when the contract purports to confer a benefit on that party, that third party. You must be familiar with this. Who is speaking and in which case?
Achaje.
In Queer versus Royal Exchange Assurance.
And that is correct. Justice Archer in Kura versus Royal Exchange Assurance. University of Ghana. Who made this statement and in which case? No court is contaminated by bad language. And I ought not feel the sense of inhibition which both counsels seemed to have felt when it came to reading aloud the words alleged to have been used by the defendant. What was proved was that the defendant spoke and published of the plaintiff that, quote, her vagina stinks, end quotes. The court is not desecrated by foul language. You have heard this too often. Who is speaking and in which case?
Justice Apalu in Wenchua and Redua.
And that is correct. Justice Apalu in Wenchua versus Redua and another. Now to you, UPSA Faculty of Law. Unmistakable. You can't miss. And I'm so certain about that you can't miss. Who made this statement and in which case? You cannot put something on nothing and expect it to stay there. It will collapse. Who is speaking and in which case?
Martin, Amidu versus Kofo, Pega JSC.
You have one more opportunity. That's incorrect. You cannot put something on nothing and expect it to stay there. It will collapse.
MPP versus Attorney General, Bamford JSC.
I'm sorry, that's not correct. Please tell me you know it. University of Ghana, you don't?
No, please.
No idea?
No.
Who in the audience does? Yes, sir. That is correct. The famous and our best Lord Denning. Thank you very much. Lord Denning in McFoy versus United Africa Company Limited, 1962. 1962. Where was MPP? Right. It's your turn, University of Ghana. Who is speaking? In which case? The procedure where a person alleges that a provision of the Constitution 1992 in respect of the fundamental human rights and freedoms has been or is or being likely to be contravened, then without prejudice to any other action that is lawfully available, that person may initiate action in the High Court. The procedure where a person alleges that a provision of the Constitution 1992 in respect of the fundamental human rights and freedoms has been or being likely to be contravened, then without prejudice to any other action that is lawfully available, that person may initiate action in the High Court. End quote. Who is speaking in which case?
NPP versus Attorney General Bamford Adu.
Incorrect.
Sam number 2 versus AG.
That's also incorrect. And you have exhausted your attempts. Yes. Abrefi and Lomoki, did you have an idea?
No.
Justice Doche in Abena Pokoa versus Agricultural Development Bank. Now to you, UPSA Faculty of Law. Here is your very short statement. If on the face of the agreement there arises any ambiguity or uncertainty as to the construction or interpretation of a clause or a term therein, it must be construed against the maker. Who is speaking? Which case is this?
Asari versus Attorney General, Dateba JSC.
Incorrect.
It's a contract case for no evidence. Sophia Akufo.
Not correct either. University of Ghana, any ideas?
No, please.
No idea. Anyone in the audience? Justice Mills Odoy in Pra and others versus Anane, 1964. And the very final quotation goes to the University of Ghana School of Law to identify who is speaking in which case. A successful plea of mistake wipes out any view of consensus and destroys the foundation of an agreement. Who is speaking and in which case? Lady and gentlemen. And this case has been in contention in my courts, this courts. Any ideas? Still no? Francois JSC in Adai versus Pania Tobacco Company Limited, 1989-1990. And that ends the quotations. Now, gentlemen and ladies, fix your gaze on the screen. And I will first invite the UPSA Faculty of Law to identify the image in your shots. Who is that?
His Lordship Justice Jones Doche.
That is correct. His Lordship Justice Victor, is it Maulom Doche of the Supreme Court of Ghana. Now, the University of Ghana School of Law. Who is in your shots?
Justice Nene Amegacha.
That is also correct. His Lordship Nene Abayate Ofoe Amegacha of the Supreme Court. And that brings us to the end of the third round of the sixth contest. A round of applause once again for our contestants. At the end of the third round of this contest, the University of Ghana made 20 points. The UPSA also made 20 points. A round of applause for our contestants again. The Law Challenge. Now we come to the fourth round, the final round in this very context between the University of Ghana and the UPSA. This is the rapid fire round. And in this round, you each will appoint a captain. You answer 10 questions within 120 seconds. There will be 3 points for each correct answer. Ladies and gentlemen, shall we begin? And this time with the University of Ghana. Here we go. Who is your captain? Thank you. So, detenue is action in personam, whilst conversion is action in rem. True or false?
True.
It's false. In conversion, the value of the goods is assessed as at the time of the conversion. But in detenue, it is assessed as at the time of the judgment. True or false?
True.
That is true. In causation, the victim's refusal to undergo medical treatment or her lack of proper care of herself subsequent to the injury does not break the chain of causation unless the victim's conduct amounts to a reckless and wanton disregard for her own health or condition. True or false?
True.
That is true. Where an injury intended for X falls on Y by accident, the perpetrator is said to be responsible for Y's injury. This constitutes direct intent. True or false?
False.
That is false. The trinity of prudence, convenience, and logic cannot override clear constitutional provisions. End quote. This statement is attributed to Justice Dr. Databa, JSC. True or false?
True.
False. A constitution is the outpouring of the soul of the nation, and its precious lifeblood is its spirit. End quote. Which of the following judges is the statement credited to? Is it SOA, JSC, as he was? True or false?
True.
That is false. Where the property is not used in the public interest or for the purpose for which it was acquired, the owner of the property immediately before the compulsory acquisition shall be given the first option for acquiring the property. True or false?
True.
That is true. Only a allodial title holder can make grants of virgin forest land to strangers for cultivation. True or false?
True.
That is true. A usufructuary holder needs the consent of the allodial owner to grant a lease out of his interest. True or false?
False.
That is false. An act done calculated to cause harm, not by physical means, but through emotional distress and psychological harm, will fix the accused with liability. True or false?
True.
It's false. A round of applause for the University of Ghana School of Law. Now it's your turn. The UPSA Faculty of Law. Who is your captain? Lomoki. Any question as to the existence or content of a rule of customary law is a question of fact for the court and not a question of law. True or false?
True.
It's false. The 1992 Constitution provides that the appellate jurisdiction of the National House of Chiefs shall be exercised by a judicial committee of the National House of Chiefs consisting of 3 persons appointed by that house from its members. True or false?
True.
It's false. Under Ghanaian law, a promise to keep an offer open for acceptance for a specified period of time is not binding on the promisor unless it is supported by consideration.
False.
True or false?
False.
That is false. The statutory provisions which change the received law on privity of contract are found in section 8.1 and 8.2 and 9 of the Contract Act 1960 Act 25. True or false?
False.
That is false. To succeed in malicious prosecution, the plaintiff must prove that the prosecutor procured, instigated, directed, ordered, or was actively instrumental in the prosecution being set in motion. True or false?
True.
False. It is only the person who is the legal owner of the property or land that can sue in nuisance. True or false?
True.
It's false.
False.
A induces a person in a state of incapacity from idiocy or intoxication, or a child under 12 years to consent to the hair of that person being cut off by A. The consent is void. True or false?
Please read it again.
A induces a person in a state of incapacity from idiocy or intoxication, or a child under 12 years to consent to the hair of that person being cut off by A. The consent is void. True or false?
True.
True. The but for test is used to determine causation. True or false?
True.
That is true. Ghana's first Chief Justice was in the person of John Mensah Saba. True or false?
False.
That is false. In land law, the denial of title of an allodial title owner by a customary freeholder or usufructuary title holder constitutes abandonment. True or false?
False.
That is false. A round of applause for the UPSA Law Faculty.